Good afternoon, and thank you for joining this webinar entitled Juvenile Record Clearance 2017 Legislative Reforms. My name is Alex Lessman, Policy Analyst for the Criminal Records Project at the Council of State Governments Justice Center. The Council of State Governments Justice Center provides practical, nonpartisan, research-driven strategies and tools to increase public safety and strengthen communities. Before getting started, I'd like to briefly go over a few housekeeping points about how the webinar works. If you encounter any technical problems, including audio problems during this webinar, please call WebEx Technical Support at 866-229-3239. Again, that number, 866-229-3239. This information is also located in the chat box to the right of the screen. Please understand that there may be some technical problems we cannot resolve. For this reason, we are recording this webinar and will post it on our website at cleanslateclearinghouse.org. We expect to have the webinar posted in the coming weeks. At any time during this webinar, you can ask a question by typing it into the Q&A box in the bottom right-hand portion of your screen. This includes both technical and content-related questions. We will reply to technical questions as we go. For content-related questions, we will keep a running list and address them at the end of the webinar. We will do our best to get through as many questions as possible. Today's presenters are Serena Holte of the National Juvenile Defender Center, Megan Garvey of the Orleans Public Defenders, and Lisa Minutola of the Delaware Office of Defense Services. We'll be hearing from them shortly. This webinar is part of the Clean Slate Clearinghouse, a project funded by the U.S. Department of Labor and the U.S. Department of Justice. The Clean Slate Clearinghouse was created to support juvenile and adult record clearance around the country by, first, providing up-to-date information on record clearance, as well as contact information for legal service providers in all U.S. states and territories. Second, developing tools and resources for legal service providers currently engaged in record clearance work, or those who want to expand their criminal record clearance services. And third, providing information to compare record clearance policies across jurisdictions and to learn about best practices. The site was designed to serve three target audience groups: people with criminal records who are seeking to have their record cleared, legal service providers who offer record clearance services, and policymakers and stakeholders who want to compare record clearance policies across the country. We expect that the site will be useful for reentry and workforce service providers who can connect people to services, indigent defense attorneys and pro bono attorneys who are interested in starting or expanding a record clearance practice, and researchers and journalists who want to compare trends in record clearance legislation across the country. The primary goals of the Clean Slate Clearinghouse are to provide accessible, up-to-date information for record clearance policies across the country and to increase the capacity of legal service providers while creating a community of practice around record clearance. We encourage you to visit the website and sign up for our newsletter to receive information on news, events, and webinars such as this one. Now, I'll turn it over to Serena Holte.
Hi, everyone. Thank you so much for joining us today. We are talking about juvenile record clearance. And some of you might not know or understand juvenile records, juvenile court system. One of the things I often hear from those who do not regularly practice in this area is, why do we need to clear juvenile records? Aren't they all confidential anyway? Well, actually, 42 states have some aspect of their juvenile records available to the public. Therefore, majority of young people who will go through our court system could have a public record. So it's important that not only adult records are cleared, but that juvenile records also are cleared. And in 2017, there were many reforms that took place in legislatures throughout the country. Today, we're going to highlight a few of them, just to give you information about where we've been and where we think we're going in the realm of juvenile record clearance law. So as we stand now, and as you'll see on the Clean Slate Clearinghouse website, there is a wide variety of juvenile record clearance laws. We have what records are eligible to be cleared. Well, there's court files, what we call social files, which might include psychosocial evaluations and probation officer notes. There's law enforcement records, records from placement, such as an out-of-home placement that might be in a secure facility or a group home. And then there's also school records. All of these might be affected in some way through the record clearance laws of different states. And then there's eligible offenses. Each state varies in this area widely. Misdemeanors, felonies, certain misdemeanors, certain felonies. What do we do about dismissed cases, or what do we do about matters where young people who were arrested but never charged? Certain states will have only certain types of misdemeanors eligible to be cleared, only certain types of felonies. Maybe it's all misdemeanors or all felonies, and maybe some dismissed cases can be cleared. But then there's almost always exclusions to those, whether it's you're no longer eligible for record clearance if you have more than one adjudication, or that you're no longer eligible if you have a subsequent adjudication or conviction, meaning later on after the adjudication you're trying to get cleared at this point. Or even just a subsequent arrest for a felony in some states make you ineligible for juvenile record clearance. And then there's whether or not it's an automatic process or whether a petition is required to be filed to get the juvenile record cleared. Some offenses may be cleared automatically. For example, there could be misdemeanors. If you have successfully completed your probation following your misdemeanor offense, then your record is cleared, or automatically without you having to file a petition. Or there could be matters where if your case was dismissed altogether, that doesn't require you to file a separate petition. It automatically is cleared. And then there are matters that, states will require you to have a petition. Some states require a petition for clearing dismissed cases. Some states require petitions for clearing matters even if you successfully completed your probation requirements. And all of this information is laid out on the Clean Slate Clearinghouse website. There's also varying levels of procedure that's required for getting your record cleared. Sometimes they require specific documents. A certified copy of your criminal history or fingerprints must be filed along with a petition. Certain individuals or entities must be served with your petition. A hearing is required if the prosecutor objects. Some states require separate petitions be filed for offenses in other counties. So if a young person has 3 offenses and only 2 are in this county and 1 is in the county next door, you have to file separate petitions, one here to address the adjudications in this county and one in the next county to address those adjudications. States also vary on whether the record clearance is discretionary or mandatory. For example, a state like Washington actually has a mandatory. Most of their juvenile record clearance laws are mandatory. If a young person has met the threshold requirements, then therefore the court doesn't have discretion, they must seal. The court's discretion to grant petition, or the court is required to grant if certain criteria is met. Sometimes it's objective criteria, sometimes it's discretionary criteria. We included it on the website to only say mandatory if there's absolutely no discretion in the decision. Then there's the waiting period. This can actually be a pretty convoluted area. There's some states that say January 1st of the year following your 21st birthday will your record be cleared, eligible to be cleared, sorry. Then there's other ones that say you are eligible after a certain number of years have passed since your case was terminated. Other ones, it depends on the young person's age. And then finally, states have a variety of filing fees. There's some states where there is no filing fee at all, some states where there are filing fees, but they can be waived, and then there are other states that require filing fees and there's no possibility of waiving those fees. So for an example, South Carolina has a tremendously high filing fee. There is a fee for the solicitor to do the research to agree and begin the process of filing your petition for record clearance there, and that can't be waived. But in 2017, we did see quite a few legislative reforms. There was an expansion of access for human trafficking-related offenses, such as in Indiana, Kansas. There was a decrease in waiting time in several states where it may have been a 5-year required wait, and now it's only 2. There's been an increase in many states for eligible offenses. Some states were very tight in the number and types of offenses that were eligible to be cleared, and they have opened those up to include other types of offenses. States have increased which records can be cleared automatically, where the young person's not required to come in and file a petition. And then also there were states that simplified their record clearance process in some other way, whether it was no longer requiring a hearing if nobody's objecting, or that there doesn't need to be proof of a certain level provided at the hearing, whether it's making it mandatory versus discretionary on the judge's side. So there's been a lot of movement and legislative reform related to juvenile records, and we're excited to see what happened in 2017. And today with us we have 2 folks who were in the trenches in 2017 working really hard in their states to get their legislative reforms through. And first up, we have Megan Garvey from the Orleans Public Defenders.
Hi, thanks, Serena. Hello? Can everyone hear me? Hello? Can everyone hear me?
Yes, Meg. Nobody's going to.
Okay, sorry. It was just doing something. My phone was making a funny sound. Hi. Thanks, Serena. Yes, this is Meg Garvey. I'm currently with the Orleans Public Defenders. I previously was with the Louisiana Center for Children's Rights, which is where I was when we were working on all of this. So, yeah, so the first thing that I want to touch on is the ABA Model Act governing confidentiality and expungement of juvenile records. And I just want to call everybody's attention to this because it was really instrumental in being able to visualize what a better expungement law could look like, and also just to be able to have that sort of imprimatur, as it were, of the ADA when you go to present your ideas about what should be changed to other people. And that's something that's easily available online. In fact, I think we'll be able to present the link if everyone can't see. I tried to post it, but we can share it with the group if not, but it's pretty easily found. And then the other thing I want to say is just that the Juvenile Law Center had done a lot of research comparing different states and the different aspects of their expungement and confidentiality processes, and that was also really helpful just to be able to show, sort of compare and contrast where Louisiana was and what was considered best practices, and to show that we were definitely not using best practices. So the 2017 effort to change the expungement law for juveniles was actually not the first go-round for this effort. The Law Institute of Louisiana, which is an organization that was created to be like a law revision commission, a law reform agency. They have a particular children's code committee, the children's code being what governs what happens in juvenile court here in Louisiana. So there had already been a push to reform some of the expungement rules. And oddly enough, one of the reasons why it didn't gain any traction in the legislature initially was that there were reforms going on with the adult expungement process, and somehow, I don't quite understand, but they believed that somehow letting those reforms go through and then seeing what happened would somehow influence juvenile expungement, which makes absolutely no sense since the rules governing expungement come from the Children's Code for juveniles, and in criminal matters come from the Criminal Code. But nevertheless, there was already some traction within that organization to get this moving. So there was already a proposed bill from the Law Institute, and it really did propose a lot of good changes, including shortening the waiting period for getting expungements, addressing some of the fines and fees issues, et cetera. But it really didn't incorporate a lot of the really promising ideas that are in the ABA model. And so our organization, along with the Louisiana Youth Justice Coalition, came up with our own bill, and we really did just use a lot of what was in the ABA model to try to write that. There were a few things where we had to compromise, which I'll get into in the later section, because they may be things that people will run up against in their states. So we were able to develop our own bill, and then we were able to get our Bar Association here in Louisiana to sign on in support of it, which one would think, because it's an ABA, because it was based on the ABA Model Act, that would be very easy, and that we would be a shoo-in, but that's not necessarily true. It's actually sort of a complicated process, but having them in our corner and being able to share with legislators that yes, they do support this and they do believe these changes are important was really helpful. So once we had that support from the state bar and the coalition, we were able to go, and this really did, like, having a lobbyist was actually helpful in this respect, just in terms of like reaching out to legislators and making sure that everybody felt comfortable with the process. What we did was we were able to sit down with the legislator that was putting forth the Law Institute's bill and some of the leaders of the Law Institute, and we were able to agree on a compromised bill that really does incorporate a lot of the things from the ABA model bill and does fulfill a lot of the best practices that the Juvenile Law Center recommends. So yeah, so it was like a slightly complicated process, but I just bring that up just to say that sometimes you really, have to push through and really reach out to lots of different people and be willing to, be creative about, how you collaborate and reach out and compromise. One thing that I will say in terms of our strategy is that this was definitely not one of the legislative things where we had a major public campaign. You know, we didn't do a lot of major messaging to the public. We did mostly concentrate on messaging to legislators and the Board of Governors for the bar. And I think part of that is just because even though I think once you get into working with young people in this system, or even when you work in the criminal system and you see the collateral effects of juvenile records or of, you know, the violation of privacy that can arise from a lot of these things, then you start to understand the negative effects. But I think that one reason why it can be hard to message the need for these changes is that a lot of people don't really realize what a lot of the negative effects of having a juvenile record are, and don't, like, I think a lot of people presume that the records are more private than they are. And so this just wasn't, you know, one of the issues that we did a whole kind of public education campaign on. Trying to click. Okay. So some of the changes that we were able to accomplish here were that we increased the eligible offenses. So pretty much, yeah, actually everything is expungible. Every juvenile adjudication is expungible in Louisiana. Now, there are different procedures and time periods depending on the charge, but now everything is able to be expunged. So previously, in Louisiana, in order to have a misdemeanor adjudication expunged, you had to wait 2 years. Well, you had to be 17, and you had to wait 2 years after there was no longer jurisdiction over your case. And for a felony adjudication, you had to wait 5 years. And, excuse me, and those rules applied seemingly even if you had been found not delinquent, or if cases had, there had been a nolle prosequi entered by the state, and that you had to go through this whole process even if you hadn't been adjudicated, which seemed obviously very unfair to us. We were able to change the process so that for the majority of juvenile adjudications, once your disposition has ended, then you are automatically eligible for expungement. And in the matters where there was no adjudication, you're automatically eligible once the case is disposed of. Now, the only charges where you have to have a longer waiting period, which is 5 years, is for charges like murder, rape, kidnapping, etc. And those charges were actually not eligible for expungement at all previously, so it still is a huge improvement. The other thing is that we made expungement mandatory, except for that top class of charges, the murder, rape, kidnapping. So unless you have a pending felony charge in criminal court or a felony conviction in criminal court, then you'll be eligible for expungement. One of the things that we really hope to do, and Serena touched on this, and this is something that was recommended by the Juvenile Law Center, was to try to automate the process. We really didn't want it to have to be, on the burden of young people to have to seek this out, because number one, they're still, trying to make their way in the world and get everything together, and, a lot of them wouldn't know how to go about doing this. But the other thing is that they're not in contact with a lawyer or an advocate necessarily to let them know that there's any need to do it or to explain the process at all. And most young people are not going to want to return to juvenile court if they don't have to, right? They're probably happy to leave that behind them and to try to move forward with their lives, which is meant to be the promise of the juvenile system, right? We're supposed to be trying to help young people move forward and not keep dragging them back. Unfortunately, we weren't able to fully automate our process. And part of that has to do with the way that Louisiana is organized, which is that each jurisdiction has its own clerk, and there's not a uniform system across the state. And so when we talked with clerks, which we actually did go out and talk with the head of the Clerks Association for Louisiana to see sort of what input or objections they might have in advance, they were very concerned about putting the individual staff members of clerks' offices in a position where they would have to be making legal decisions, and we felt that that was a legitimate objection, and we didn't want to put something forward that we thought was in danger of not passing because of their objection. And so what we came up with was kind of a hybrid, compromised method of doing things. And to be clear, since this just passed last year, I think we may need a little bit more time to see if that is actually the best way of doing it. But what we developed was a system where, going forward for new cases that came about after the law was passed, that the court would include a motion to expunge in the record right when the disposition was given to the juvenile, and that would not be executory until the disposition ended, so that the process would already be starting, and that the young person wouldn't need to hire an attorney and come back into court and move forward in that way. So that was sort of our attempt to try to automate it somewhat. Now, obviously, we had to account for all of the people who were retroactively eligible for expungement. So there is also a process where they can come in and file for expungement on those charges. And then additionally, for the people who have been adjudicated of those most serious charges that I mentioned, then they can also file a petition for expungement in those matters. A few other things that changed. There are no longer any court fees associated with juvenile adjudication. Now, there are still some other fees out there that the state police assess, but those are waivable if there's a showing of indigence, which is a pretty low bar in Louisiana since children are presumed indigent. And trying to think what else. Oh, also as to the human trafficking issue, which Serena also brought up, we made it so that any young person who was adjudicated of any prostitution type charge could get that adjudication expunged immediately, because we felt that that was in keeping with some other sex trafficking provisions that were moving forward in the legislature at that time. I think that's it for the major changes. But one other component of our bill, which I think is important to mention, was that we changed the confidentiality rules and really tightened those up here. And I think that that often needs to go hand in hand with any efforts to address expungement, because there could be other ways that information gets out there, and I think, with the sort of changing landscape and thinking about technology and the internet and everything, that I think that just trying to keep the information from getting out in the first place is also sort of part of our larger goal, which is protecting young people and protecting their future opportunities. And so we really tightened the rules on what information can be shared with the public, can be shared with the press, and just made the process of going about and getting that information more stricter and more uniform, so that there would be judicial oversight about any information that was getting out. So I think that's most of the major changes, but obviously I'll be happy to answer any questions at the end.
Thanks, Meg. And then for Delaware, we have Lisa Minutola.
Hello everyone. Thank you very much for attending today. I am the Chief of Legal Services for the Delaware Office of Defense Services, which is the agency that supervises both the traditional public defender's office and the Office of Conflicts Counsel in Delaware. And in my role, I do now mainly policy and legislative work, although over the years I had worked in the various courts, including family court, where I was the supervisor and handled delinquency matters from 2005 to 2009. Delaware has a pretty complex juvenile expungement system at this time, and I can sort of echo a lot of what I heard Serena say, that how, you know, states have these various systems, and in Delaware, I think we have parts of all of that system within our own statute. So there are certain offenses that are mandatory expungement. There are certain offenses and adjudications that come under discretionary expungement. There are a few things that you can have immediately expunged, so it's not quite automatic because the court still has some discretion, but they can do it right then and there in the courtroom. There are fees associated with the criminal record that you need to file with your petition in order to get your expungement. So we have a lot of those same structures that you see in some of the other states, as well as some of the same issues like the fees and like the fact that many people just don't understand that their juvenile record does stay with them. In fact, when we try to call clients to alert them to the fact that they have a record and we can assist them with an expungement clinic, we often have to argue with the individual or their parents, if they're still a juvenile, to explain to them that, yes, even though you went to court and even though the case was dropped, that arrest is still on your record. So that education piece has still been ongoing. So in Delaware, in around 2011, the expungement statute was actually overhauled in what was an attempt to streamline it and actually make it a little bit more like the adult statute, which had also gone through some streamlining. And there were some good things that happened in 2011, but one of the problems was that this was a consensus piece of legislation, and our counterparts at the Department of Justice, which is the prosecuting agency in Delaware, was part of that that working group. And so obviously when you have your opposition at the table with you, it can be good and bad. It was good in that the piece of legislation that was presented to the General Assembly was one where all of the parties agreed upon, and the General Assembly usually likes to hear that both the defense and the prosecution are in agreement on controversial pieces of legislation. But at the same time, that meant there had to be some concessions that were made. And unfortunately, at that time in 2011, although the Public Defender's Office was somewhat involved in that legislation, I have to be quite candid and say we did not do many expungements back in 2011, so I didn't have as much of an understanding as I do now of what some of the consequences were and what the legislation should have looked like. And we had some private practitioners who helped us with that legislation. And starting around 2014, those same private practitioners came back to us and said, you know what, this isn't necessarily working. We have a lot of clients who come to us that we still can't get expungements for, even under what was supposed to be this expanded piece of expungement legislation. And so we began to work with them to really craft a new expungement bill. And to be quite candid, at this time we didn't have the Department of Justice at the table. So we drafted the bill to look how we wanted it to look. And that was introduced in 2014, sort of at the end of the session, so it didn't get far, but that was really what we ended up modeling the legislation that did pass in 2015, 16, and 17 that I'll talk about in a minute on. So not only did I work with a few private practitioners who had experience as former prosecutors and now as defense attorneys, but we also had nonprofit organizations, and the main one being the Delaware Center for Justice, which helps both offenders and victims in Delaware, and because they have that dual role, they've been around for decades in Delaware, they have a very strong reputation in Delaware, and they have a very strong advocacy component. So they were great partners to have to lobby for this legislation, and they also were able to pull in other nonprofit groups, and they really put together a juvenile justice coalition that they had different groups sign on to support the legislation. We also work with the Juvenile Law Center, as Megan mentioned. The report that they did comparing the 50 states and really rating them on their juvenile expungements and confidentiality laws was very helpful because, unfortunately, Delaware ranked very poorly in their report. I think we were somewhere around 46th or 48th in terms of having the worst juvenile records policies around. And so we were able to use that to really kind of shame the General Assembly into saying, hey, we have to do something because we don't want to be this, you know, seen as this bad. And so those are some of the key allies. Some of the unlikely allies really were trying to get in some groups that looked more at an economic perspective. And really our Department of Labor actually has a part of their division of vocational rehab. They have a small office that is called Apex, and they handle adult pardons and expungements. And so we partner with them because they were able to really give us some perspective and give us some support as well about the collateral consequences that they saw, with individuals who had a record and weren't able to get jobs and educations. And then we also were able to get bipartisan support for this. So this wasn't just a, sort of a liberal, democratic, progressive movement. Our Republican senators and representatives really began to buy into this as well. And I think it really comes along from those economic issues because they realized that we had people that we were basically disenfranchising that could be successful members of society but weren't able to get a job or get an education or get housing. And it just led to a cycle of either them reoffending or those individuals having to rely on public assistance, and that was not something that they wanted to see. And so this really became an economic issue and a fairness issue, especially when it came to individuals who had offenses for which they were not adjudicated of. And really to explain to some legislators that, yes, even an arrest for which you were not adjudicated of, you were either found not guilty, it was dismissed, or it was dropped, is still on your record. And from both sides, really, that was kind of shocking, and they wanted to see that changed. And so really the strategy that we used was we were able to tell the tale of individual personal stories. And we had two wonderful individuals that we worked with for the last few years. And they both kind of just fell into our laps. We were really fortunate. The first young man, Alex, he attempted to get an expungement of his robbery in the first degree adjudication that occurred when he was 16 years old. He was now 24 years old. He had an attorney who represented him, and her petition was denied. And she was friends with another attorney from my office. So through that attorney, she contacted me because she knew I had been working on expungement reform, and you wanted to make sure that this was correct. Why was it that this one particular adjudication was not going to be able to be expunged? And it was because our statute had said basically that one of the offenses that was excluded from expungement, if you were adjudicated of it, was robbery in the first degree. Other than this conviction for robbery in the first degree, and it had some associated offenses like conspiracy with it, Alex really had no other record whatsoever. So at 16, he and a few friends decided to rob a pizza delivery man with a BB gun. He, prior to this, really had been doing well, had been in a parochial school for like grade school, and then his mom, he came from a single-parent home. His mom fell in some hard times, took him out of the parochial school, put him in a public school. He wanted to fit in with the crowd and began to associate with kids who maybe didn't make the best choices. And so, they one night went and decided to rob the pizza delivery man with the BB gun. Once he was caught, he made a full confession. He, kind of turned himself in. And he ended up taking his plea to the robbery in the first degree because of the fact that it had this BB gun attached to it that the state was alleging was actually a firearm. And if convicted of it, he faced the possibility of being convicted in adult court and facing mandatory jail time in adult court. And so he ended up taking this plea that led him to a year in our juvenile facilities back in 2009. In 2012, when he was getting ready to file his petition for expungement, that is when our laws actually changed again, and that robbery in the first degree was excluded from being expunged. So up until about a month before this law changed, he was thinking that he was going to be able to get his record expunged. So flashback from 2012 now to 2017, his attorney tries anyway to get it expunged. It's not expunged. And he is a very dynamic, charismatic young man who, even after having this adjudication in a year at our the fairest school for boys in Delaware, was able to go to the Delaware Technical Community College and graduate with honors, and then go to Wilmington University and eventually go on to get his master's degree, and works for a company now doing IT. At the time, though, he was actually trying to get into the financial services industry with the same company, and when they ran his background check, that's when his juvenile record came up. Luckily for him, and unlike most of our clients, he has such a good rapport with his supervisors that they decided to keep him despite his record, but he had to shift his focus from the financial sector to the IT sector because he couldn't get his financial services license. And if you could see and meet this young man, he would, you would be taken by him just as the legislators were. I mean, they absolutely love him. By the time this bill got passed, he was getting hugs from members of the House and the Senate. And then we have a second gentleman, Steve, who I don't want to call him the older gentleman because he's only like a year older than me, but he is around 50, and between the ages of 10 and 14, he had adjudications for breaking into garages and taking a couple motorcycles for joyrides, and then I think breaking into a vacant building, and they might have like had a party in there. And then because he was put into a secure facility, he walked away from one of those facilities to actually go home and see his mom, and he had an escape in the second degree, which is a felony level in Delaware. So he basically had 3 different felony level offenses about 3 different times between the ages of 10 and 14. He also went to the Ferris School, and once he was released at age 14, his mother, along with actually the judge and a local police officer, helped get him on track. And by age 18, he ended up working for, I think, interning and then getting a job with this company that's a global company that does like your vinyl siding and piping and like the plastic that goes around the windows. And so his job now entails actually going to the plants that are in all across the country and actually all across the world, going to those plants and doing quality control and supervising and making sure everything is going according to plan. And in around 2012 or so, he had to go to Canada. And all of a sudden he was told by his job that he couldn't go to Canada. They couldn't get him working papers because his juvenile record had popped up. And, excuse me, he was shocked by this. He did not realize, like many of our clients, that his juvenile record would be accessible and that it would hamper him. And so he began fighting to get his record expunged, and because he had multiple adjudications over multiple years, our statutes did not allow this, and his private attorney, who was one who actually had worked with us on these reform bills, brought him to us. And so when he told his story, you know, he looked like any one of the male legislators that could be sitting in that room, and they were, again, shocked to hear this story. And so those real-life stories really brought it home. The other thing we did was we did package this as part of an overall juvenile justice reform. So there were a few bills really centered around giving the courts more discretion to handle juveniles in a developmentally appropriate way. And that includes things like letting police officers divert kids prior to arrest with a civil citation program, or eliminating kids that would be transferred to adult court. And so we really package this up as part of a whole series of reforms. As I mentioned earlier, and I think as Meg mentioned as well, this doesn't all happen overnight. So there was multiple drafts over multiple years. Our bill in 2014 never even got out of committee. In 2015, we only got some small changes. In 2016, we added on to the changes, and finally in 2017, we were able to get it to where we're happy, but we're still not satisfied, and we still have some more bills that are going to come up in this session. I think the biggest thing was, as you've heard from some other people, educating the legislators that these records still exist, that they're still accessible, and that the collateral consequences from them really do cause harm to our clients. And so what we ended up doing, and by the time we were all done with this package of bills in 2017, is sort of similar to what Meg said. We've expanded the number of eligible offenses, and so at this point in Delaware, almost any adjudication is eligible to be expunged at some point, with the exception of a few pretty serious offenses, and that's murder in the first degree, murder in the second degree, rape in the first degree, rape in the second degree, arson in the first degree, and kidnapping in the first degree. And some of those are even cases that are generally prosecuted still, unfortunately, in our adult court. I would like to still work on getting rid of that prohibition, but we were able to get rid of the prohibitions on robbery in the first degree, home invasion, and burglary in the first degree in 2017. We streamlined the process, so now that individuals who are having their cases terminated in their favor, so dismissed or found not guilty or dropped or complete a diversion program, those can be done automatically and immediately in court if they're misdemeanors. And we have a bill right now to expand that to felony offenses as well. And then we also shorten some of the time frames in terms of how long people have to wait. So the longest wait, and it still is a long wait, is if somebody has multiple adjudications that include violent felonies. They do have to still wait 7 years. That was a little bit of a compromise, at least in order to get that category of violent adjudications where there's multiple adjudications on the table. Part of my strategy has always been, let's get the eligibility first, and then once people are comfortable with actually expunging these charges, then we can work on more technical issues, which would be shortening the amount of time. So the statute's rather complex. To kind of explain all of it, I think I could be here for an hour and a half, which is generally how long our expungement training takes. But I'd be happy to answer any questions offline or at the end of this about what we did. One other quick thing that was helpful was for part of this, the national campaign to reform state juvenile justice was active in Delaware, and through their grant money, they were able to hire a lobbyist and a strategist, and they were both people that I was very familiar with. In fact, the attorney who was working as their lobbyist was an attorney who used to work with our office, so we were able to really work with them hand in hand, and we were able to eventually do a lot of press around this, and even as recently as just within the last week or two, there was some press about our recent juvenile justice reforms, and the gentleman, Steve, that I talked about earlier, who was the one who had his adjudications between ages 10 and 14, was interviewed to give his entire story, and again, even the reporter was like surprised to hear what he had to go through to eventually get his record expunged, and we've gotten a lot of positive feedback on that, and we hope it will lead to some more changes. So thank you very much.
Thanks, Megan. Thanks, Lisa. Appreciate that. There are some other states that also made some major changes in their juvenile record clearance laws in 2017. So Illinois is an example of another state. Illinois expanded their automatic expungement to include cases that were dismissed. It really helps a young person to be able to move on, especially when there was not an adjudication, to have automatic expungement. And so in these cases, we've seen especially a larger increase in states including matters that are dismissed amongst those that can be automatically cleared without the requirement of a separate petition. They also, what seeming to be maybe a minor change but actually can make a big difference is that a hearing is now only required if the prosecutor objects. That is a huge difference in timing. Oftentimes things can get backed up in the courts if we actually have to have a hearing on the petition. And so if the prosecutor is on board with the petition to clear the record, and the judge can make a decision based upon the papers and doesn't require to have a separate hearing, the process can be much faster, and the young person can get the relief that they're supposed to get in a quicker fashion than having to wait for an actual hearing. And sometimes those hearings, when the prosecutor doesn't object, are just very fast and simple, and the judge hears that the prosecutor doesn't object and therefore is granting the petition. So it definitely is also for judicial economy purposes helpful in that way. They also decreased their waiting periods. Some matters you had to wait 5 years before you'd be eligible to clear those records, and now they're down to 2. And having long waiting periods can become a huge hurdle and a problem. You know, young people, as they're becoming adults and they're trying to get into college, they're trying to get jobs, they're trying to get housing, we have these long waiting periods, and those are the times in which those young people need help and not hurdles. And so by decreasing the waiting period, they're allowing more young people to be able to overcome those issues and more likely to be able to get into school, to get that housing, or to get that job. And like what they did in Louisiana, they also strengthened their confidentiality laws. As I mentioned at the beginning, that juvenile records are not confidential in every single state. There are a variety of ways in which states treat juvenile records and who can look at them and who can have access to them, what would show up on a background check. And so if you start to limit the access to juvenile records from the beginning, we have less work on the other end to do to try to correct or minimize the damage thereof. And the reason why we emphasize this in juvenile court is because we're talking about children, we're talking about young people. We've all made mistakes and had problems and did things that we don't want the world to hold against us for the rest of our lives. And so we're really through this process have seen more and more states allow more young people the opportunity to clear their records. And California also made great strides this last year. There have been these certain offenses called 707B offenses, and they're certain serious offenses, and there would be, in this list, there's offenses that you kind of would think are on the more serious offense list, but then there's some that are surprisingly on that list. So they're treated different. 707B offenses are treated different for varying reasons and in varying contexts in California law. However, California this last year has opened up those offenses to be eligible for record sealing, for juvenile record sealing. And that is very helpful because 707B offenses are actually available to the public in California. So now that they're eligible to be sealed, it's helpful for those young people to not have that to follow them and create those lifelong hurdles. California also increased the matters eligible for automatic sealing. So before it was actually more difficult to get a case that was dismissed or a case or an arrest that was never charged off of a record than it was for one in which the young person successfully completed probation following an adjudication. So now California has expanded their laws to allow for eligible automatic sealing for cases in which they're not pursued, that are dismissed. The court has decided they didn't supply sufficient evidence, or the prosecutor has otherwise decided to dismiss the case. So this is a slide showing you which states made legislative reforms in regards to juvenile record clearance in 2017. Because there's so much white space, you might think it was actually a majority of states that didn't, but it's actually 26 states that made changes to their juvenile record clearance laws and have, expanded them in the way that we have explained here today. So why do we expand juvenile record clearance laws? I talked about that a little bit before, but it's so important that we give young people an opportunity to move on beyond their youthful mistakes. We have heard a lot about adolescent development and brain development, psychosocial development, and these are record clearance is a mechanism in which we can make sure that these mistakes are not used to hold someone down or to continue to be a hurdle to the young person succeeding in life. We want to make sure that every young person has the opportunity to get a job, to get stable housing, to go to college if they want to go to college, and not be put down and prevented from going down those paths just because they made a mistake as a young person. And in 2018, there are states that are lined up to change their juvenile record clearance laws and court rules. So we at the National Juvenile Defender Center have supported and have seen that there are bills presented in several different states. One in particular is for Nebraska. Nebraska has open juvenile records. All records are available to the public in Nebraska, and Nebraska has legislation pending that would simplify their sealing process and make more young people eligible for record sealing. And in a state where all juvenile records are available to the public, that's highly essential and very important. And in New Mexico, they have a Supreme Court rule that is up for comment to solidify their sealing process of juvenile records there. And both of these would be very helpful for young people to be able to ensure that their records are not continued to be used against their success in the future. So we had presenters of Megan Garvey from the Orleans Public Defenders and Lisa Minutola from the Delaware Office of Defense Services. This is their contact information. Please feel free to reach out to them if you have any questions, but you can also, now is the time to ask questions of our presenters or of me here at the National Juvenile Defender Center. We are so grateful for the opportunity to discuss with you the legislative reforms that have taken place, and we look forward to seeing what's going to happen in 2018 with more expansion of juvenile record clearance laws. If anybody has a question, please feel free to put it into our Q&A box. You will see a box at the top right of your screen that says Q&A with a question mark in it, and then at the bottom there will come up to be a box in which you can type your question if you have any. Well, as presenters, we'll stick around for a couple minutes for those who might be still typing in your questions. So I'm fine with there being just a little bit of silence while people may be typing in, but we greatly appreciate your participation in today's webinar. And here's my contact information where you can reach me at the National Juvenile Defender Center. Also, if you have any questions or would like to discuss anything in regards to the juvenile record clearance process in your state or around the country. So we have a question of, could you speak more about what arguments work for convincing legislatures to move toward automatic expungement? Sorry, I apologize. Some states call it expunction, some call it expungement, some use the word deletion. And I'm going to leave that up to Meg and Lisa to answer first, and I'll follow up.
This is Lisa. One argument is just really judicial economy. So it's going to save everybody a lot of time and resources to do this automatically versus to do this in another fashion, especially when we were talking about offenses for which the person was not found guilty or delinquent, when they really had been successful in the resolution of their case. It didn't make a lot of sense to the legislators to have that person have to leave the courthouse, file a petition, get their certified record, and then come back into court to get that record expunged when we already had determined that that was a mandatory expungement. They said, why couldn't we do it all right then and there in the courtroom? Obviously, the court has a record that it's using when it's resolving this case to determine, you know, jurisdiction or appropriate sanctions or whatever the case may be. Why couldn't we just do it all at one time? That seemed to be a very successful argument that we eventually were able to win with.
And this is Meg, and I would just echo that about the judicial economy and just like the economic aspect of it, like you know, not having to afford public defenders for people for all of these processes, et cetera. But to be honest with you, I don't really feel like I got a lot of pushback on that other than, as I mentioned, you know, from the clerks, you know, point of view of just not wanting to be in a position of making legal decisions, you know, without a judge's signature or a judge's order on something. But other than that, we didn't really get a lot of pushback. But I think just in terms of simplifying the process, we definitely talked a lot about, you know, the economic aspect of it and just spending less money on the system to make these things happen.
And this is Serena, and I definitely agree with those, and I also think that it's important to point out that we're talking about children, and we're talking about youthful mistakes here, and if we're requiring young people to come back to the courts and file petitions and everything, it's a big hurdle, because these young people, and I've been traveling throughout the country for the last couple of years talking about these issues, most people assume that juvenile records just disappear when they turn 18, that they're not going to be a problem, and no background check will ever show a juvenile record. But as what Lisa explained earlier and in many other examples, they do come up and they do become a problem. And, you know, Lisa's examples are of people who are, you know, able to get connected and have the resources to address those, but many young people don't. And they don't know it's a problem until it becomes a problem, and now they've been denied that job, and they have been, or they've been kicked out of that apartment, or whatever the problem is that's now become a huge issue in their life. And if we could have just addressed that by automatic expungement, it would have been much easier for everyone, and then no one would have to deal with, now we've got a homelessness issue or whatever the issue might be. So I think there's adolescent development and transition to adulthood arguments to be made that could also be effective. Another question is about working with, someone mentioned that they work with a number of NGO programs assisting juvenile offenders. We typically, on our end, don't use that term. We'll just say young people who've been involved in the juvenile court system. They typically have to document the offenses in order to serve youth. How should they handle the youth file if their record is ultimately sealed? So it actually depends on different states. Number one, most states, and I think it's all but maybe one, that actually indicates that a juvenile adjudication is not a criminal conviction. If a question is asking about criminal convictions, a young person, adult, whomever it is, would not have to disclose a juvenile adjudication. It is not a criminal conviction. The other point I want to make is that it all depends, if a record's been sealed, it all depends on how that state defines sealing. What does sealing mean? What's the effect of sealing? You can find on the Clean Slate Clearinghouse website what the effect is in every state. Some states, sealing means that the person can deny it ever happened. In other states, it just means that file is now held in a more secure place where less people can access it. So it really varies by state. But for your specific state, I would suggest looking at the Clean Slate Clearinghouse website, which is cleanslateclearinghouse.org, and finding out specifically what is going on in your state. There's one more question. Have you noticed any judicial backup in completing sealings? with automatic ceilings caused by a lack of funding or resources. So in Cook County, Illinois, that was a problem. There was a backup of, there were cases that the prosecutor was not objecting to being cleared, but they ended up having this backup because it required there to be hearings. And, you know, the court's calendar is already packed and full. And so when people are trying to file for an expungement, it could be scheduled many months down the road. And even though there's no objection, it can cause a major delay. And that ends up being a problem for many folks.
Serena, this is Lisa. We've seen not necessarily a backup, but the way the statute is in Delaware, the State Bureau of Identifications has 60 days to remove the record once it's been granted, but the family court holds the record for about 45 days because they want to make sure there's no appeals or other issues that come up. And so then there's very, very limited time on the back end for the State Bureau of Identifications to process this, and we're trying to work through that issue. And then the State Bureau of Identifications has partnered with us in terms of hosting some expungement clinics actually at their facilities, because that's the agency that has to also run the record. So they've been very good with us. So we've been trying to keep them in the loop to not overburden them, but at the same time make them understand that we do have to expand expungement. So, you know, that's kind of one of those sort of you know, unlikely allies as well, because they are law enforcement, but at the same time, a lot of them understand why we need to do the records clearance, and so they, you know, we've been trying to work with them. And as we've increased expungements, they have had some concern about, you know, we're going to have more work to do with less resources, and what is that going to do to them? But so far, so good.
And another quick example is in South Carolina, where they have the non-waivable fee that most people don't even have that kind of money, and it can vary between, I think, $275 and $315, or no, I'm sorry, $285 and $315, and that is a lot of money. And for somebody who's needing to get their record cleared, most people don't have that kind of money. So very few people actually take advantage of record clearance and juvenile record clearance in South Carolina, strictly because of the money issue. And we do have another question. What are some of the justifications or reasons given by prosecutors in opposition to automatic expungement? Lisa or Meg, do you have an answer?
I think that you know, sometimes prosecutors are just concerned about, you know, making sure that they're going to still be able to do their work, and law enforcement sometimes is concerned about still being able to use this information somehow to investigate, and there was a lot of talk about that. But if you really think about it, the fact that whether or not somebody had a juvenile record really has very little investigative value. It has quite a bit of profiling value. Yeah, so I mean, a lot of the pushback was that somehow, you know, if things were expunged, then there would somehow hamper investigations, and that argument sort of fell by the wayside because I don't really think that it holds a lot of water. But I mean, if everybody is served, then everybody's on notice, you know, about what's going on. And I will say that one thing that we did to try to limit the sort of blanket objections for expungement was that we included in our bill an actual form motion that prosecutors can use to object, and it gives, you know, their specific reasons that they're legally allowed to object so that you have notice of what their objection is in advance. And I think that just kind of helps keep everybody efficient, right? In terms of, you know, some agencies may just like blanket object, but now that they actually have to say in writing what their objection is, I think it sort of tamps down those sort of blanket objections. But yeah, I mean, I do think people thought that somehow this was going to infringe upon their ability to investigate somehow, and it really just doesn't do that. And so ultimately we did not get a lot of pushback there at the end.
And I echo what Meg said. We also hear arguments just like, for the more serious offenses. Well, these are really serious offenses, and we're not sure whether or not they should be expunged. We might want to have a record of them, and some of these arguments sort of still the old 80s, 90s, super predator, children are bad arguments that are so out of date now that I don't think they held much water. But we heard sort of some of that at first, that we had to be careful about this, and we consider whether or not they should be expunged. We ultimately were able to overcome most of those arguments.
And I think some people just have a hesitancy to destroy any files, right? Some agencies are just like, oh my gosh, I want to be able to hold on to this. I don't really know why. I just want to be able to hold on to these records. And I've seen that a few times too. That they're just not sure, it might come up and it might be something I want to be able to use and look at in a later circumstances. But when you ask them what those might be, I tend to not get too many very specific examples. But what maybe there could be this one possibility of something. As you can tell, we're all a little biased. We all appreciate the effectiveness of automatic expungement. And I don't see any other questions for us. We're so appreciative of you all participating today. Again, please contact us if you have any questions, and we'd be happy to talk with you and work with you on any of these issues.